Till now, we looked at the principles of legislation that covered why laws are made. Now let us look at the principles that are connected with how laws should be made. These are also very simple and easy to understand. For example, the first principle is the principle of legality, which means that the laws themselves should be legal. For example, the Constitution grants some powers to the government and also sets some limits, which means that the laws should not exceed those powers and must be within the limits set by the Constitution. Equality, which means that the laws should apply equally to all citizens without discrimination on any grounds such as race, gender, religion, or social status. Proportionality, which means that the consequences of contravening or breaking any laws should be proportional to the severity of the offense. Very severe punishments for small offences or for offences committed unintentionally are not proportional. Public good, which means that the legislation should aim to promote public interest, welfare and security while balancing individual rights with the collective good of the society. Separation of powers. This principle ensures that the legislative, the executive and the judicial powers are distinct and separate and provide a level of checks and balances on each other to prevent abuse of power by any one branch. Transparency and accountability, which means that the process of making laws should be open and transparent and the lawmakers themselves should be accountable to the public for their own actions and decisions. Principle of due process, which means that the laws must guarantee a proper process and fair procedures for determining rights such as the right to a fair trial, the right to be heard, the right to appeal. Clarity and predictability, which means that the laws should be written clearly and precisely so that people can understand their rights and obligations. This predictability allows individuals and businesses to plan their actions accordingly, and any ambiguity or doubts in the laws should be interpreted in favor of the accused or in favor of the defendant. Human rights protection, which means that the legislation should protect and promote human rights, ensuring that the laws do not infringe on the fundamental freedoms and rights which are recognized by national and international law. And participation, which means that the process of lawmaking should allow for the participation of those affected by the laws, which means that the process of lawmaking should allow for the participation by the citizens. And it should also provide avenues for public input and feedback. You will see that all of these principles are common sense, and many of these principles such as legality, equality, separation of powers, due process, human rights protection are built into the supreme rule book of the country itself. That is, they are built into the Constitution.